There's a really good old school hip hop song, and I can't remember who it's by, but it goes something like "Tag teams back again," and I wish I could remember the rest of the lyrics. It applies perfectly to Dan Goldman and Jim McGovern, who they've been in this House hearing into Mayorkas and various other things that the Trump Republicans are up to, and they have been just spot on.
And he says he needs tools and so forth. He has the tools. He could stop it immediately, literally under existing law. Now, why do we need changes to existing law? Well, as we are trying to manage a system where we handle immigration, the current system is being exploited. I want to see if the gentleman agrees with this, where we have the general black letter law and spirit of the law that is security, right? Operational control of the border. You cannot come in without papers, right? Like that's the baseline. Then there's legal immigration. We'll invite you to come here. Here are some papers if you apply and you can get them and you're in the right line and the right standing. And then there's people who come here. And they come here and they try to claim something. True or false, this administration has been using asylum and parole as effectively a backdoor way to use those limited exceptions that are supposed to be predominantly case by case to use as effectively the exceptions that swallow the rule of security, right? That along with judge-made loopholes like Flores TVPRA with those complications. So those smaller provisions are being used to say, everybody come, make a claim, and get released. Is that a fair characterization in your observation?
Absolutely, and that's exactly what the lower court, that the Supreme Court chose not to overturn or make a decision on, exactly said that he had basically turned the whole immigration system upside down.
And the impact of that, right, just to see if these sounds correct to you, that of the sort of 3.3 million illegal aliens released into the United States since January of 21, the Biden administration failed to remove, through immigration court removal proceedings, roughly 99.7% of those illegal aliens. That compared to an average between FY17 and FY20 of 590,000 aliens encountered per fiscal year, we had over 1.4 million in 21, 2.3 million in 22, 2.4 million in 23. Impacts on cities and states. New York has spent $1.5 billion on the crisis. Texas has spent $12.5 billion on the crisis. Smuggling organizations estimate revenues increased from $500 million in 2018 to $13 billion in 2022. Immigration court backlog has increased from 1.3 million cases to 3 million cases. I could go on and on. The fentanyl numbers have gone from 4,800 pounds in fiscal year 20 to now we're in excess of, I think, 40,000 pounds or something in those rough estimates. And then the terror watch list, 11 total fiscal year 17 to 20, 331 total fiscal years 21 to 24 under Biden. So these are all concerning results, right, of open borders. Would the gentleman agree?
Absolutely.
And that's a fair characterization, plus more and stuff that you've got replete in all of the documentation of those numbers, and obviously they change on a monthly basis. I would ask, if I might, to introduce into the record 4 documents, because I've been working on this for a while, and to counter the point of the ranking member that this is somehow political. This is a response to President Trump. I mean, if the gentleman wants to give the president a call down to Mar-a-Lago and explain, you know, what I was doing in Iowa the last month, I'd appreciate him doing that. But I would say that in October of 21, I laid out a case in long form, laying out the case for impeaching Mayorkas in a 13-page memo to my Texas Republican colleagues. In March of 22, about 5 months later, I updated that memo to the entirety of the GOP colleagues. In July of 23, I wrote an op-ed in National Review titled "The Constitutional Case for Impeaching Mayorkas," and earlier this month, well, actually last month in January, I sent another memo updating the case for impeaching Mayorkas. Again, updating the numbers, keeping the general framework. I think the gentleman has seen some of that work. It's a result of work in Judiciary Committee. I'd ask all 4 of those to be entered in the record.
Without objection.
The reason I bring that up is because, far from being political, this was October of 21, 10 months into this administration, where if you go look at that memo where we lay out the stark shift from January of 21 to October of 21, it was blatantly clear that the Secretary of Homeland Security was ignoring the laws, and that ignoring of the law was endangering the people I represent. That was the fact of the matter. Would the gentleman agree with that, and not just Texas, but also the people of Tennessee and other people around the union?
100%.
And along those lines, in the articles that have been presented, the secretary has willfully and systematically refused to comply with the law. Notably, for example, you have in here INA 235B, INA 236C, and a host of other statutes in which the secretary is required, right, to faithfully execute the laws. True?
That is correct, yes.
And at some point, then that is the question. And to the gentleman from Colorado who raised the questions about, well, you know, what is the mens rea and what are the elements of the crime? Where in the Constitution, if the gentleman, the learned doctor, you don't have to be a legal scholar to be able to read the Constitution, where in the Constitution of the United States is there anything that mentions elements of the crime or mens rea with respect to impeachment?
It's not there.
It's not there.
Right.
Now, why might that be? Because it's a political document, right? This is a political question. Now, it is a political question based on law, right? Based on our understanding of how we want to apply the laws. But where in the Constitution are high crimes and misdemeanors defined? Is there a definition section in the back?
No.
That defines high crimes and misdemeanors? So where might we go to determine high crimes and misdemeanors, right? History, experience, try to figure out what it means. Now, my friend from Colorado, which was here, because I referred to him in the third person, he's not here, but raised, as I believe a couple of other of my colleagues on the other side of the aisle raised, and actually a couple of colleagues on this side of the aisle have raised, the question about maladministration, which I do think is an important question. Whether or not high crimes and misdemeanors was meant to include maladministration or whether maladministration was specifically rejected. Now, I could be wrong, and I'm certainly open to be corrected for the record because I think this is an interesting history. I don't know that it would be dispositive either way. But it is my understanding that it was in fact not rejected by vote, but rather when it was suggested by Colonel Mason and I think seconded by Mr. Gary, that then there was a point raised by Mr. Madison that I believe the gentleman from Colorado quoted, "So vague a term will be equivalent to a tenure during pleasure of the Senate," end quote. And then there was some one-sentence debate here, and then Colonel Mason withdrew maladministration. It was not voted on. He withdrew maladministration and substitutes, quote, other high crimes and misdemeanors. Now, the point of that was that it was not, in fact, rejected, and it was not defined. Of course, that is a then question about whether or not maladministration, what was the concern about it? Some of these debates would go back during the 90s, during the Clinton debates, about whether you have to have done something in your official capacity versus your personal capacity, and all of that has been a significant debate. But I would note, and ask to insert into the record a law review article here from Duke University, without objection.
Without objection.
That in here, the author writes, a close reading of the Mason-Madison exchange discloses that it does not support either view in terms of the debate that they were having at the time. That first, the convention itself did not reject the term maladministration. Mason introduced the term and withdrew it after hearing Madison's objection. Because there was no vote, there was no opportunity for the delegates to adopt or reject Madison's concern. Second, according to Blackstone, British common law had developed a definition of high crimes and misdemeanors that included, but was not limited to maladministration. The phrase also encompassed unofficial misconduct, etc., and it goes on. While Madison may not have known this, Mason apparently knew at least that it encompassed maladministration. Now, I'm not suggesting that I know exactly what they meant. I was not there. I am not suggesting that I think that it should or should not be a broad application of maladministration. That is a debate. But the simple truth is, it's up to us. So the question before us, I think, is one more of whether we open a door. We open a Pandora's box, right? That's the question that we would wrestle with here. The question here is whether the Secretary of Homeland Security has engaged in such conduct by ignoring the laws of the United States that you could reasonably suggest that he is violating his oath, right, to faithfully execute the laws of the United States, right? And on behalf of the president, for whom there is, in fact, phrasing in the Constitution that he must take care, right? And this, I think, is the center point of this entire debate. No one wants to have to go down the road of impeaching a secretary appointed and then confirmed by the Senate of the United States. I certainly don't want to do that. I assume the gentleman from Tennessee doesn't want to do that. Is that correct?
No.
Probably one of the last things you want to do, right?
Exactly.
And so people say, well, this is a big political, scalp. Look, I mean, I tweeted out today, not shockingly, contra some of the interests of my Republican colleagues, that I might find it interesting that some of my colleagues would very much appreciate being able to say they impeached Mayorkas, but not actually get funding removed and have a spending fight in order to stop what's happening at the border. I have no interest in doing that, and most of my colleagues have no interest in doing that. It's a question. It's an academic question. We're here, as you said at the beginning, about whether or not, in fact, I think the question was raised by the ranking member about something about a date, right? April of last year, and that you set out to do this and had some sort of mission to do this. And then there's some questions about whether or not, with respect to Mayorkas, about whether or not the fact that it might fail in the Senate or some other political questions. And your response, I think, was exactly right. I want to ask you to elaborate on it if you want, that we have a duty to do it. If we believe that there is, in fact, a public official who has a duty under law and under the Constitution to enforce it, we have a duty to call that secretary out, force him or her to the table, and then, in the absence of a response to the elected representatives of the people, take action. And you're either defunding or you're impeaching. And you're impeaching under whatever you believe the understanding is under the law on high crimes and misdemeanors. I believe that a violation of the oath, that rises to that level. For example, if the Attorney General of the United States were to order all of the Department of Justice, United States attorneys, stop prosecuting crimes. Just sit back. Let everything run amok. Now, there might be a statute that violates. I'm not sure. I'd have to go comb through the statutes and say that. But that would be a gross violation of that individual's duty under the Constitution. And if the president wasn't asking for his or her resignation, do you not agree that it would be incumbent upon us to say, you can't do that?
If I could interject,
sure.
Though, the laws don't direct him to do it. Right? There's no law that tells the DOJ you must go and capture every single murderer. But the law written by this body is very clear. You shall detain. And for criminal aliens, criminal felons, it's you shall detain all of them. And then there are directions to ICE about immediate deportation once it's determined they don't have an asylum claim that's legit. This secretary has not detained. In fact, has done everything he can to not detain and has not deported. The numbers are all plummeting. I mean, they're building systems and mechanisms to do just what the law.
Does his own admission of 85 to 90%, which he is on record in terms of people acknowledging that he said it in front of people that works for him in Texas, 85 to 90% of the people being released into the United States, does that comport at all with any understanding of how we're supposed to assess credible fear and make determinations before releasing the United States versus the law requiring detention?
Not at all, because he's created these alternative pathways that don't exist in law, that actually subvert the law's intent of a case-by-case basis to get to parole.
Does the gentleman, in addition to the secretary violating his oath, his duty to enforce the laws of the United States, is the gentleman aware of a instance in which the secretary lied or misrepresented the facts under oath before committees, before this body?
Yes, I am very aware of multiple statements by Secretary Mayorkas where he said, by the definition of operational control, that he and the department had operational control of the southern border. There are multiple episodes of that, and other instances where he said the border's been secure when clearly it's not secure. Yeah.
Now, the response to that, as you would expect, right, from our colleagues on the other side of the aisle, and I would suggest maybe if it was in reverse, the response, if our side was trying to defend the secretary, is, well, those are vague terms, right? That, well, the secretary comes and he makes assertions about how he's carrying out his job and his perspective of it and that sort of notion of administration or maladministration. But I wonder if the gentleman might respond to the exchange that I had with the secretary, in which in April 19th, 2022 hearing in Judiciary Committee, I read word for word on a poster in the Judiciary Committee the statutory definition of operational control under the Secure Fence Act of 2006. Gentlemen, you're aware of that exchange, correct?
Yes, I am.
And I asked the secretary, quote, do you stand by your testimony that we have operational control in light of this definition? Now, I would just add here, I had already asked the question, set it up, He said we have operational control. I pulled up the chart, put the actual definition of operational control under the Secure Defense Act of 2006, and he replied, quote, I do. And Congressman, I think the Secretary of Homeland Security would have said the same thing in 2020 and 2019, end quote. Now, in a side note, as a conversation with Chad Wolf, the former secretary who appeared before the committee, I asked him that question. And he said, I very expressly never said such a thing. What I said was, we are making great progress to achieve what is trying to be accomplished under the Secure Defense Act to try to achieve that number. And for the record, they were doing that. They were trying to figure out how to enforce the law to drive those numbers down in accordance with the operational control definition. My point of bringing that up is because in March 28th of 2023, not quite a year later, Senate Judiciary Committee, in response to a question by Ranking Member Lindsey Graham on whether we have operational control of the border, the Secretary said, quote, with respect to the definition of operational control, I do not use the definition that appears in the Secure Fence Act, end quote. The Secretary's playing games, and he's playing games very specifically with those definitions so that he can give the appearance to the American people that the border is secure, because most people aren't following it like we are. Most people are just going about their daily life. They're taking their kids to games. They're going to their job. They're, paying the bills. They're going and getting the groceries. They don't follow all this stuff, but they see masses of people at the border and they wonder what the hell is going on. So then you go tell them, well, the President of the United States is just making unilateral decisions to let lots of people come into our country, which, by the way, is undermining our national security, undermining our security. And they say, well, that's crazy. Who would do that? Why would they do that? They're the president. They're the secretary. They're supposed to enforce the law. And then you come back and say, well, by the way, I had the secretary in front of me. That's my job. I asked him a question. I was very specific. I gave him lots of room. I said, well, surely, if you look at this definition, you can't tell me you have operational control, Mr. Secretary. And he very boldly claimed that he did. And that is the problem, right? It is a snowing of the American people. There's further engagement with this that I won't belabor here because for time's sake, in which there's been abundance of, well, and this actually is important because in July of this last year, in the House Judiciary Committee, I questioned the Secretary again. After laying out the timeline of his previous statements, I asked, you looked straight in the American people, straight at me, straight at every person in this committee and said, we have operational control. Why? He said, you did not let me complete my answer. The Secure Fence Act defines operational control as not a single individual crossing the border. To which I said, I'm aware. I read it, and I read it to you, and you read it, and in fact, you said, I do. You didn't hesitate. You didn't say, I do. I need to explain what I mean by I do. You said, I do, over and over again. Any comments on that and what that gives in terms of your belief that the Secretary should be impeached?
Well, we clearly believe that a breach of trust of both Congress and the American people is fairly articulated in the Founding Fathers' description of high crimes and misdemeanors. We've actually had testimony from the minority witnesses in our committee that said breach of trust is a high crime and misdemeanor. I genuinely believe that when you lie to the American people, when you lie to the Congress under oath, that is a breach of trust. If you look at the impeachment articles that were drafted against Richard Nixon, they very clearly don't name him for committing any crime, but they do say for giving false testimony and for making false statements. So that was an article then. Clearly it's precedent, and that this Secretary has lied to the American people on multiple occasions. The horsewhipping incident. I mean, the list goes on and on and on.
Yeah, last point.
And Congress under oath, too.
Last point, I'll raise that one. The Secretary knew full well, prior to issuing the statement about the alleged whipping incident, in which lifelong public servants, Border Patrol agents, were being accused of the most vile and vicious, hateful, race-based kind of behavior. He, in fact, was made aware prior to the press conference that this was, in fact, not true. Is that true?
That is correct. He knew before he went out to the press conference, and then he lambasted those gentlemen.
And is that lying and mischaracterizing of the faithful public servants of DHS and Border Patrol agents, is that a violation of the public trust to drum up that kind of hatred?
Absolutely. It was clearly political.
The Secretary has, on numerous times, undermined border security, terminated border wall contracts. He sued Texas most recently, multiple times, frankly, and recently for trying to implement border security measures. issued a memorandum that said the fact the individual is a removable alien should not be the sole basis of an enforcement action, which is basically rewriting the law by memorandum. I could go on and on. I think the main point here is, and I appreciate the chairman, I just want to push back on this notion that somehow this is, at least when I speak for myself, and I think for you, and I'll let you speak for yourself, that this is politically motivated. At the end of the day, you know, I'll tell you this right now. If Secretary Mayorkas would call me up right now and say, you know what, I apologize for what I did to those migrants, those Haitian migrants. You know, I should have been more careful in my definition with what I said to you in committee about what operational control is. We're going to fix this. We're going to go work with Texas. We're going to enforce the law. We're going to start detaining people. We're going to tell the world that we will detain you, legitimately, fully detain you. Otherwise, you're not coming in, because that's what our law contemplates. And we're going to do that, and we're going to send a message to the world so that cartels aren't empowered and people aren't going through this Darien Gap, traveling all the way up through Mexico with rape trees and people getting abused, and all the way through up, riding on the top of train cars, all the stuff that we're causing this to happen to Americans and to migrants in this false name of compassion. The secretary would call me up and say, hey, let's get busy. You're right. Let's enforce the law. I had no interest in having a scalp with respect to the Secretary of Homeland Security. What I really want is to make sure that we're doing our job. Does the gentleman agree?
Absolutely. You know, for me, that little baby crawling around on a VRBO that stumbled into fentanyl that had been left by the previous renter of the VRBO and died tells me that every American is unsafe with this open border. And I am passionately here because I believe it's the right thing to do.
I yield back.
Thank you very much. Gentlelady from Indiana is recognized for whatever question she has for the panel.
Thank you, Mr. Chairman. Thank you, Chairman Green and Ranking Member Thompson, for coming to the Rules Committee today. Chairman Green, I'd like to just start by commending you on your work throughout this process. Your committee has been incredibly methodical in getting to this point. I know today we don't have as much time here to talk and spend as much time as your committee has on the process, but I was hoping that we could you could walk with me through sort of summarizing the conversation and clarifying the most important points. First thing I want to do, though, is read directly from the Department of Homeland Security's own website, specifically with their mission statement. Quote, with honor and integrity, we will safeguard the American people, our homeland, and our values. It goes on to state, the U.S. Department of Homeland Security and its Homeland Security mission are born from the commitment and resolve of Americans across the United States in the wake of the September 11th attacks. In those darkest hours, we witnessed true heroism, self-sacrifice, and a unified resolve against evil. We rallied together for our common defense, and we pledged to stand united against the threats attacking our great nation, fellow Americans, and way of life. Additionally, they've got guiding principles. DHS quotes that they will remain resolute against today's threats and hazards by keeping pace with our adversaries and preparing for those of tomorrow by identifying and confronting systemic risk. It goes on to say Homeland Security is a whole of society endeavor, from every federal department and agency to every American across this nation. We will work together and empower partners to leverage national capacity and capabilities and develop contingency plans that make America safe, secure, and resilient against all threats and all hazards. Mr. Chairman, does the department's actions, particularly against the state of Texas in their own efforts to secure the border, live up to that particular guideline?
Not at all.
DHS goes on to say that it will ensure its operators and employees have the necessary tools, resources, and authorities to execute its mission. It goes on to talk about the core values of the Department of Homeland Security. Integrity. Each of us serves something far greater than ourselves. To our nation, we represent the President and the Congress. To the world seeking to visit or do business with us, we are often the first Americans they meet. We will faithfully execute the duties and responsibilities entrusted to us, and we will maintain the highest ethical and professional standards. Regarding vigilance, we will relentlessly identify and deter threats that pose a danger to the safety of the American people. As a department, we will be constantly on guard against threats, hazards, dangers that threaten our values and our way of life. Mr. Chairman, would you say that Secretary Mayorkas is living up to their own mission, stated mission, guiding principles, and core values.
I want to say that the people of the Department of Homeland Security, I just recently, have been to the border, of course, and I've been through our border, our air border, and the people are doing the very best they can. This isn't an issue of the employees of DHS. This is an issue, and if you talk to Border Patrol, Border Protection, they'll definitely tell you they're doing what the Secretary's told them to do. And
yes,
it's not what they want.
Chairman Green, I have also visited the border, and I totally agree with you.
Yeah.
My criticism here is specifically to the leadership of Secretary Mayorkas in his directives that I, quite frankly, don't believe live up to the mission and guiding principles and core values of what the Department of Homeland Security should be.
I agree.
I want to touch just a little bit on the work that your committee did, particularly that Secretary Mayorkas has willfully refused to comply with numerous detention requirements spelled out by the Immigration and Nationality Act, instead implementing a mass catch and release scheme. In fact, you've found, I think, 7 different violations, at least, Mr. Chairman, of the Secretary Mayorkas in violation of the Immigration and Nationality Act. Is that correct?
That is correct, 7. And
in that, certain of these requirements that he has failed to follow, they require at least 5 times that I see the statement in the law, shall be detained. Does catch and release and shall be detained, are those two things substantially similar or substantially different?
They are diametrically opposed.
So would you say the primary responsibility of the Secretary of the Department of Homeland Security is to oversee the department's efforts in safeguarding the United States' national security?
Absolutely.
8 million people have been let into this country under the Biden administration since in the last 3 years. That's 1 million more people than the state of Indiana, which I represent. Is that number accurate?
That is correct.
Is it true that CBP has encountered 49 individuals on the terrorist watch list in this fiscal year alone?
Yes, 49.
Is it true that the United States Customs and Border Patrol had a record more than 300,000 encounters at the southern border of the United States in December of 2023 under Secretary Mayorkas?
302,000, yes.
Is it true that CBP has reported 1.7 million known gotaways?
I think it's at 1.8 million now.
Is it true that DHS has lost 100,000 migrant children?
Yes, it is.
Has the Department of Homeland Security, under Secretary Mayorkas' leadership, made policy decisions that may have led to the consequences that I have just described?
Absolutely. The policies are the cause.
Is it true that after multiple attempts to have Secretary Mayorkas appear before your committee, that his team responded at 4:48 a.m. on the day of the markup with a letter defending himself and his decisions? That
is correct. We attempted 4 times to get him to come, and he did not. He evaded, wouldn't answer, said no in some instances, and then at 4:48 in the morning sends us his written, I think it was 7-page letter.
Chairman Green, did Secretary Mayorkas meaningfully engage within your investigation?
No, he is continuing. I think on 40 occasions we still have outstanding. I mean, we've had to subpoena him to get some stuff, but there are multiple examples, and I believe 40 where he's just refused. They don't even answer. We send stuff over. They don't even acknowledge that they've gotten it.
Mr. Chairman, did Secretary Mayorkas comply with the laws of the United States, which his agency is bound by?
No.
With respect to his oath to support and defend the Constitution of the United States against all enemies, foreign and domestic, has Secretary Mayorkas upheld that oath with a border open to drug cartels, criminals, human traffickers, and potential terrorists, a fentanyl epidemic destroying American communities, a record number of migrant deaths, rising human trafficking and the exploitation of minors, a public health disaster, and an annual net burden to the American taxpayer exceeding $150 billion?
I believe his oath to the Constitution is violated by his refusal to recognize the separation of powers in the Constitution and that we write the laws, they execute them, and he has failed and actually intentionally subverted some of those laws.
Thank you, Chairman Green. Thank you for your leadership. It's certainly sad to find ourselves in this position. The cabinet-level secretaries are responsible for their actions, just as any of us are. We must hold the secretary to account. I appreciate you doing so. Thank you, Mr. Chairman, and I yield back.
Thank you. I appreciate both of our witnesses, particularly it was a long session, so thank you both for coming back, and the witnesses are excused.
Thank you.
Mr. Chairman?
Yes, sir.
Can I ask unanimous consent to insert into the record a letter from the Department of Homeland Security to the Rules Committee regarding the resolution, and the letter reads, in part, I quote, "The effort to impeach Secretary Mayorkas represents a dramatic departure from over 2 centuries of established understanding and precedent about the meaning of the impeachment clause of the Constitution and the proper exercise of that extraordinary tool."
Without objection.
Thank you.
Now invite our panel. I think, Mr. Goldman, you're the only one here, so if you'd come forward, and we may have another person joining you. We'll see if we have some others that wanted to come.
Thank you, Mr. Justice. Mr.
Is it? Okay. I think you'll be our only witness.
All right.
Okay. Mr. Goldman, you're recognized for any amendment you care to offer or any remarks you care to make.
Thank you very much. Thank you. I do have an amendment that I believe is at the desk. May.
Certainly in order. The gentleman's recognized.
And essentially what this amendment does is it strikes every mention of the word scheme in the articles of impeachment. And the reason for this is there is no evidence, there is no proof of any scheme that we would understand from any variation of civil or criminal law. There has been no evidence, and I specifically asked this during the markup, of Secretary Mayorkas's intent or willfulness to disobey the law, and therefore there's certainly no evidence that there's any scheme or conspiracy of any sort to do so. I had the pleasure of listening to the last couple hours of questioning of the chairman and the ranking member, and there are a number of things that have been represented to this committee that are plainly false. First of all, there's no court that has made any ruling that determines there's no court that has definitively determined that any action by Secretary Mayorkas has been a willful or intentional violation of the law. Chairman Green and the articles reference 7 laws that have been violated. First of all, there's no court that has said that. In fact, there's a Sixth Circuit opinion that says the opposite. And what's, I think, particularly misleading is the reference to the Supreme Court case on United States versus Texas, which Chairman Green referenced and was referenced extensively in the markup as demonstrated as being reversed on standing only, and therefore the district court opinion, or rather the circuit court, Fifth Circuit opinion should therefore, the rationale should hold. I just want to read a quote from the majority opinion. It was an 8-1 decision, and it was written by Justice Kavanaugh. And he is discussing the executive branch discretion to enforce the law, and that the executive branch, especially when it comes to arrest or prosecution, has a broad discretion because, quote, 1, the executive branch invariably lacks the resources to arrest and prosecute every violator of every law, and 2, must constantly react and adjust to the ever-shifting public safety and public welfare needs of the people. This case, he goes on, illustrates the point. As the district court found, the executive branch does not possess the resources necessary to arrest or remove all of the non-citizens covered by the relevant statutes of the INA. That reality is not an anomaly. It is a constant. For the last 27 years, since those laws were enacted in their current form, all 5 presidential administrations have determined that resource constraints necessitated prioritization in making immigration arrests. So, in other words, the Republican majority has set up an impossible standard that has never been met and cannot be met with the resources that the Department of Homeland Security possesses. Now, there was a lot of discussion of these guidelines that Secretary Mayorkas implemented to use his discretion, to utilize his resources in a effective, efficient, and the best way possible, because he cannot actually detain every single person who comes across the border. And when we talk about operational control, which I know Mr. Roy was dwelling on, based on the Secure Fence Act of 2006, in 2007, the Bush administration, Department of Homeland Security, issued guidelines that interpreted operational control in a manageable way that would allow the department to execute the laws faithfully without detaining preventing every single unlawful immigrant from coming in the country, because that is, of course, an impossible standard that no Secretary of Homeland Security has ever met. So when Secretary Mayorkas talks about operational control, he is using the definition that was drafted and created and implemented by the Republican Bush administration and has been used ever since. The reason I'm going through all of this in rebutting the specific points that have been made is because this entire impeachment resolution is a fiction. It is a pure political fiction. It's not just a policy dispute, which is the best gloss on it. It's just factually incorrect. It's not even a policy dispute. Because a policy dispute is, for example, when President Biden and Secretary Mayorkas try to change the policy at the border to streamline the asylum process, to funnel people to the ports of entry, to prevent people from making that hundreds of miles trek to the border and doing it within their own country to either apply for asylum or for a visa. When they do that, Republican attorneys general file lawsuits against the administration to prevent them from implementing policy to address the border. That is what has happened over the last 3 years. So you have Republican attorneys general who are filing lawsuits to prevent Secretary Mayorkas and President Biden from effecting the policy changes that the Republicans call for all day long, to prevent them from doing so. And then you move to impeach him by saying that he hasn't enacted effective policy to address the border. It is beyond hypocrisy. It is a terrible, terrible case of bad faith. Mr. Roy said that he doesn't want a scalp because he said that if Secretary Mayorkas came out and said, let's detain everyone, let's clean up the border, he'd be happy. He'd drop the impeachment. Well, that's funny, because I'm pretty sure that Secretary Mayorkas was deeply immersed in negotiating the Senate bill with a bipartisan group of senators that does exactly that. And I don't agree with it. It goes way too far. I think it denies due process for asylum. It takes it out of the judicial system. It puts it purely within the executive branch. It requires asylum applications to be adjudicated in 6 months. There's a 3-month detention period, and then there is a 3-month alternative to detention period, but does not allow people to leave the area. They have eliminated what you all call catch and release. It is a dramatic shift in asylum law and how asylum is done, but it is exactly what Mr. Roy asked for and says that he would be happy to drop the impeachment against Secretary Mayorkas. So finally, I will just conclude by saying that the irony that this House of Representatives would abuse and demean the impeachment clause of the United States based on their own assessment of what a violation of the law is, not a court's determination. The courts have said that, in fact, you must give discretion to the executive branch, Article 2, but based on their own interpretation, no evidence of willfulness or intent. It is simply an inability to adhere to the laws that are set because of a lack of resources. And they are trying, you all on this side of the aisle, the Republicans are trying to impeach Secretary Mayorkas because he failed to address the border literally while he is negotiating necessary and essential legislation in the Senate to address the border. The irony should not be lost on anyone. It is political cynicism at its worst. It demeans the impeachment clause. There is no basis in history or the law to say that any of these allegations rise to the level of any misdemeanor or crime, much less a high crime and misdemeanor, as it was established by the framers. And yet he is even continuing to try to do exactly what you say he hasn't done. And now you're presented with a bill that does many of the things that you want, and you're still going through with impeachment. And we all know there's one reason why, and it is November 2024. And Donald Trump wants to be able to say that Joe Biden did not address the issues at the border so that he can get elected. He would rather have continued chaos at the border than to solve the problems for the American people so that he can win. And unfortunately, there are too many of my colleagues on the other side of the aisle who are going along with it. And it is a sad, sad day in this body's history. Thank you.
Chair has no questions. Go to Mr. Burgess. No questions? Distinguished ranking member.
Well, thank you, Mr. Chairman, and let me thank the gentleman for being here for his amendment. I support it. I think it is appropriate to strike the word scheme as it relates to Secretary Mayorkas because it doesn't apply to him. The word scheme does apply, I think, to my Republican friends because there is a scheme here, and that is how to distract from their inaction on the border and on immigration. There is a scheme that involves them trying to find ways to finish what they could not do on January 6th, and that is to try to unravel this president's legacy and going after his cabinet. I mean, I didn't know that the bar for impeaching a cabinet member was so low. I mean, if that were the case, I would have moved to impeach every one of Donald Trump's cabinet appointees. I mean, who worked to gut our environmental laws, who gave comfort to Vladimir Putin, who undermined the rule of law, tons of conflicts of interest, contempt, for the poor in this country, working overtime to enrich those who are well connected and well off. That's the scheme here. And when I hear my colleagues say, "Oh, I regret that we're at this point. Oh, I'm so sad we're here. I take no pleasure in this." I don't believe them. I think this is exactly what they live for, and this is all they have left, because there's nothing they can show for their time in the majority. The gentleman from Texas, who's not here right now, has been repeatedly quoted on the fact that this Republican majority has produced nothing. He can point to nothing. So when you have produced nothing, you try to distract. Now, the gentleman played a key role in the first impeachment of former President Trump. You saw a process that was serious. How would you compare this process to that process?
Well, without getting into the merits of the two different cases, I think there are several things that are very important to point out as significant differences. In the first impeachment of Donald Trump in 2019 for extorting the president of Ukraine to open an investigation to benefit Donald Trump's personal and political interests, not the official interests of the United States, there were 17 fact witnesses who came in and testified under oath and who essentially provided a very similar narrative as to the events that occurred. And even the Republican senators, one did vote to convict the president at that time, which was the first time that any senator had ever voted to convict a president of the same party. But even a number of the other Republican senators who voted to acquit acknowledged that the facts as elicited by the documents, the witness testimony, not by members of Congress, the actual facts and evidence, proved the case. And in that particular case, the allegation was an abuse of power for personal gain, not for the benefit of the United States of America. And there was overwhelming evidence that the reason why Donald Trump, who, by the way, Mr. Ranking Member, violated the law, he violated the Impoundment Control Act. He knowingly and willfully violated the Impoundment Control Act by refusing to provide to Ukraine security assistance and military assistance that Congress had appropriated, and it was required to be dispersed by the end of the fiscal year. That is a violation of law. So if the standard that we're going to go forward with on impeachments now is that any time you violate a law, whether you're the president or you're the cabinet secretary, if I, as a member of Congress, can stand up and say, you willfully did that, even though I don't have evidence, when asked in a markup, what is the evidence of intent or willfulness, one of my friends on the other side of the aisle said, well, it's just obvious. What else would it be, is actually what he said. But even putting that aside, his violation of the law, because he was not impeached for violating the Impoundment Control Act. He was impeached because he withheld the security assistance to benefit his own personal interest, his own political campaign. And it was clear there was no other basis for withholding that. The evidence showed, the facts showed, there was no other basis to withhold that assistance other than for his personal interest. Here, in this case, there are no allegations that Secretary Mayorkas has done anything for his personal interests. There's not a single allegation. There couldn't be. He's worked for the United States government in various capacities for 22 years as an immigrant from Cuba who has given much of his professional career to this country, dealt a horrible hand, and we can debate why and how to resolve it, which is the whole point of Congress and legislation. But he hasn't done anything for his personal interest. These allegations are based on differences of how he should be handling the situation at the border. And unfortunately, that's what elections are for. And our Republican colleagues may not like that. You may have great points. You may have great reasons. You may have great solutions. But one of them is not to impeach the person trying to implement the laws, even if he's unable to do so because we as Congress do not provide him with the resources necessary.
No, and I appreciate that, and I appreciate your being here. I just say one final thing, and that is that I find it somewhat ironic that my friends on the other side of the aisle talk about the law as they fall over themselves to endorse the former president, who a jury of his peers just held him liable to pay $83 million to a woman he defamed, who it was determined that, in fact, he raped her. So let's just, I find all this so puzzling and so ironic. But anyway, you wanted to say one other thing?
Well, even putting that aside, let's talk about what has been represented here. The allegation that Secretary Mayorkas has lied, which is part of the basis of his breach of the public trust, is that he lied about a whipping incident at a press conference. So if we are now going to set a standard for impeachment, if a political or appointed a cabinet secretary, or let's say perhaps the President of the United States, lies to the public, well, I think during the last administration, we would have over 30,000 impeachments.
Yeah, well, thank you. I yield back.
Thank you. Gentleman from Pennsylvania is recognized for questions.
I appreciate it, Mr. Chairman. Just in the fact that we're running out of time, we can go ahead and yield back. But thank you.
Gentlelady from Pennsylvania is recognized.
Yeah, I just had a quick question. One of the grounds on which our colleagues from the other side of the dais have decided to impeach Mr. Mayorkas is they say he didn't come testify to Congress. And I think you've been following this pretty closely, and in fact, he has testified to Congress multiple times, but they're particularly peeved that he didn't appear before a particular committee on a date when he was already scheduled to be talking to Mexican authorities about how we could better address the crisis at the border. Do you have any knowledge of that?
Certainly. Secretary Mayorkas has testified 27 times to Congress during his 3 years as the Secretary of Homeland Security. That's more than any other cabinet secretary. The Republican majority says that he was asked 4 times to come and testify. 3 of those times preceded the passage of the impeachment resolution and preceded the initiation of an impeachment inquiry into him. After those 3 times, he did come and testify to the committee, where he was asked numerous questions about these same issues. Then he was asked 1 time to come, as the gentlelady said, on a date certain, because apparently this investigation had to be finished within the span of 3 or 4 weeks. So it was only 1 date when, as you correctly say, he was meeting with Mexican authorities, ironically, to figure out how to address the situation at the border. And he could not change his schedule.
And in fact, as a result of that meeting, didn't he reach an agreement with the Mexican authorities, pursuant to which we saw a 75% drop in border crossings at the end of this last year?
He has been working, I think, quite significantly with the Mexican authorities. Also, another major issue which we have not addressed is the hundreds of thousands of American-made guns that have gone from the United States to the drug cartels. I find it interesting when my colleagues say that the immigration, that the open border, quote unquote, that was phase 2, open border fuels the drug cartels. Well, I think the drug cartels would say that the gun trafficking from the United States to the drug cartels actually is what fuels their authority and their control over the border. But the Secretary has implemented a specific operation to address the outflow of American-made guns. There are no guns that are made in Mexico effectively. They're all come from the United States, or at least I should say at least 70% come from the United States. So yes, he's been working very hard with the Mexican authorities to address these issues.
And you had some engagement in impeachments under the last administration. Were there efforts made to accommodate witness schedules from the Trump administration?
Yes, repeatedly. The problem we ran into is many of the witnesses from the Trump administration just refused to abide by or obey their subpoena altogether. And I, once again, find it incredibly ironic that the chairman points out that there are 40 requests out of hundreds that the Department of Homeland Security has not responded to. The department has given tens and thousands of documents, has had hundreds of hours of meetings and briefings, has provided far more information and insight than or in the ordinary course, and that, of course, is compared to former President Trump in the first impeachment. After declaring he would defy all subpoenas, he then turned over 0 documents from his administration.
Okay, thank you. I yield back.
Gentlelady from Indiana is recognized for any questions you may have.
Thank you, Mr. Chairman. I do not have any questions. I yield back.
Thank you. Gentlelady from New Mexico is recognized for any questions you may have.
Thanks.